appealing the matter of Ness Global Services Ltd and Perform Content Services Ltd.
Yes, Mr. Chairman.
My lady, my lords, I appear on behalf of the appellant Perform in this matter. My learned friend, Ms Dilnott QC, appears on behalf of the respondent to the appeal, Ness. As the court is aware, the first part of this appeal concerns the question of whether jurisdiction is based on Article 4, i.e. domicile, for the purposes of Article 33(1) of the regulation, in circumstances where the respondent is an English domicile company, the party's contract contains a non-exclusive jurisdiction clause providing for non-exclusive jurisdiction at the place of domicile. Now, as my ladyship and my lords are aware, we submit that jurisdiction is based on domicile at the place of domicile, as expressly provided for in Article 4 of the regulation.
Where's the clause, Mr. Dewan? Where's the best place to look at the clause? Is it in the supplementary bundle?
My lord, it's in the core bundle,
right.
tab 9.
Mm. Yeah.
And it is at page 142, little f. So page 142, little f. Governing law and jurisdiction.
So the party's bargain was an irrevocable submission to the jurisdiction of the English court.
The non-exclusive jurisdiction.
On a non-exclusive basis, but that was the bargain that they made.
Indeed, my lord. Your lord is putting to me, I think, that some emphasis should be placed on irrevocable.
Well, that's why Article 33 doesn't touch on prorogation of jurisdiction, because the whole point about prorogation of jurisdiction is it's a bargain between the parties.
That's correct, my lord, but just in terms of the irrevocable submission point, this was a point that my learned friend put to, at first instance, to Mr Houseman QC sitting as a deputy judge. And then we got into an argument as to what irrevocable submission means and whether it takes one beyond it being a non-exclusive jurisdiction clause. And just to be clear, there was authority cited at that point in time. There was the Al Saba case, which is not before the court today, because the Court of Appeal there did not place any additional weight on it being an irrevocable submission. And that hasn't been pursued on appeal, that there's a difference, to the extent your lordship is putting to me, that there's a difference between it being irrevocable submission to the non-exclusive jurisdiction clause and just being a non-exclusive jurisdiction.
Yeah, the whole point about non-exclusive jurisdiction is that it doesn't preclude the other parties of the contract from commencing proceedings in another jurisdiction. But what it does mean is that if one of the parties does commence proceedings in this jurisdiction, the other party has contractually agreed to irrevocably submit. In other words, by its very nature, it's a sort of agreement that contemplates that there may be proceedings in two jurisdictions.
Yes, my lord. But, my lord, once again, without wanting to fall too far outside of the order in which I was intending to address these...
No, I'm sorry, Mr. Dewan.
No, not at all, my lord. There is a difference, and this is what I'm going to come on to first, between where a non-exclusive jurisdiction clause fits within the scheme of the regulation and the approach as a matter of English domestic forum non-convenience principles. And that is fundamental in my submission to this appeal. So I have fully on board what your lordship is putting to me, but if your lordship will bear with me, I want to take you through the scheme of the regulation.
Yeah.
Some material, including the POCAR report, which Lord Justice Henderson will be familiar with from the Etihad case, as to where a non-exclusive jurisdiction clause fits within the regulation is rather important in my submission. Now, before we get into that, and again, I appreciate the court has considerable familiarity with the applicable principles of interpretation of an EU regulation. I do wish to spend a short amount of time to ensure that the correct interpretive lens is placed on the issues. Because I am going to be submitting that does make a critical difference to the analysis and the point that your Lordship has just been putting to me. Now, I am going to, for the purposes of interpretation principles, I am going to be referring your Lordships and Ladyship to Briggs in tab 5. Now, just for your note, this is the 6th edition of Briggs. I have put in a small excerpt from the 7th edition, which came out in April of this year, at the end of April. The reason why I'm referring to Briggs in the 6th edition is because the 7th edition effectively focuses on the Lugano Convention by reason of Brexit. And so it's the 6th edition which...
Rather optimistically.
Rather optimistically, indeed. To be fair, Briggs spends a lot more time on the principles of interpretation in the 6th edition than the 7th edition.
Yeah, okay.
So that's why. Now, my Lord, the first point that I want to emphasize, of course, is autonomous interpretation. Tab 5, page 130. So we see the heading, the terms of the regulation are given an equal and uniform interpretation. I appreciate the court is very familiar with that. And you'll see at the bottom of page 130, there's an obvious practical benefit in the provisions of the regulation bearing to the greatest extent possible meaning which is common and uniform across the member states. And it goes on to explain how it would diminish the practical effect if a different meaning is engaged in different member states. And that becomes important, as I'm going to come on to in the context of what is the regulation understanding of a non-exclusive jurisdiction clause, which is not familiar in some member states. Now, what is said at page 131 at the end of the first paragraph is that obviously this is a matter which has been, this principle has been developed through the European Court, and it says, second, it has been met by the development of autonomous or independent meanings for the basic definitional terms of the regulation. This is beyond doubt the most characteristic feature of the jurisprudence of the court. It then goes on to give an example of whether something is to be characterized as contract or tort in this next paragraph. And what Briggs makes the point in the last sentence is this: whatever the answer is, it is not contract if the claim is brought in France, but tort if it is brought in Germany. Instead, the jurisdictional question has to be answered by use of an independent or uniform or autonomous or a-national definition. I appreciate, of course, that this is not music to the court's ears and that this is very basic principle. On the next page, at 132, under paragraph 2.04, I just draw the court's attention to the last paragraph under 2.04 and its reference in the last 2 lines, which is you have to give a meaning which is, but the direction of legal development is clear, and to put forward an argument in a case which relies upon a term in the regulation being given a meaning which is derived from the idiosyncrasy of national law is to advance an argument which exposes itself to attack. Now, so that's the first principle. It won't come as much of a surprise to the court. I have put in a case to that effect in volume 2, tab 15, the Arco-Haviland case. It's quite a well-known case. Just for your notes, so volume 2, tab 15, page 427, paragraphs 10 to 11. So that's page 427 of the European Court judgment. This case was concerned with, as you'll see from paragraph 10, the concept of matters relating to a contract serves as a criterion to define the scope of one of the rules of special jurisdiction. And then it goes on to say, having regard to the objectives and the general scheme of the Convention, it is important that in order to ensure as far as possible the equality and uniformity of the rights and obligations arising out of the Convention, that concept should not be interpreted simply as referring to the national law of one or other of the states. And then paragraph 11, therefore the concept of matters relating to a contract should be regarded as an independent concept, which for the purpose of application of the Convention must be interpreted by reference chiefly to the system and objectives of the Convention in order to ensure it's fully effective. Now, the other principle of interpretation, which is important in my submission, is going back to Briggs at page 132, volume 1, tab 5, is so-called teleological interpretation.
Yeah.
And what Briggs says under the heading 2.05 is the regulation is the latest incarnation of a legislative text designed and drafted by civil lawyers trained in the continental legal tradition and subject to authoritative interpretation by judges who are almost all civilian lawyers. It was made and has to be interpreted, has to be understood to be interpreted according to the European canons of construction, at least if it is to be understood in a way which will conform to the views of the European Court. The English approach of interpreting more or less literally the precise relevant words following the prior decisions of earlier courts is not exactly the European way. Instead, the regulation must be interpreted purposively or teleologically, that is to say, with a view which gives predominant weight to achieving the overall purposes of the instrument as a whole, as distinct from seeking to ascertain the natural meaning of a single provision taken in isolation from the rest of the text. Now, that passage, just for your Lordship's note, for the court's note, and we don't need to take it up, was approved at first instance in a case called Gulf International against Aldwood. It's a recent case, paragraph 66. The reference is volume 2, tab 14, page 379. Now, there are two further points before we get into the scheme of the regulation, just as a matter of interpretation. Obviously, all of the texts of the regulation are authentic and can be looked at, and that's Briggs at paragraph 1.14 on page 128 to 129. That's relevant in the context of the use of the term shall in Article 25, and what weight, if any, should be given to the use of the term shall, as I'll come on to. Second, there are reports on the various conventions that are a significant aid to their interpretation. Briggs refers to this at paragraph 1.15, and in the context of non-exclusive jurisdiction clauses, there's a passage from the Pokar report, which was cited by the Court of Appeal in the relatively recent case of Etihad, which I will be taking the court to as important in understanding the function of a non-exclusive jurisdiction clause in the context of the regulation. So, can we then turn to the scheme of the regulation and where a non-exclusive jurisdiction clause fits in, how this interacts with domicile under the scheme of the regulation. My Lord, have I not given you a correct reference, my Lord?
Sorry, I'm not. What's the reference?
No, my Lord. I feel that I have puzzled your Lordship.
No, I don't think so. Are you? What are we looking at next?
Well, next we're going to go through the regulation.
Right. Well, that's what I thought you were going to do. So I've got the regulation next.
Apologies, my Lord. You're one step ahead of me. So, my Lord, my Lady, my Lords, there are two gateways into the application of the regulation, and it is important in my submission to keep them separate and appreciate that we are entering into the regulation through what I describe as the primary gateway. the primary gateway to the application of the regulation applicable in this case is that the defendant is domiciled within a member state. Where domiciliary jurisdiction exists, one enters the regulation through Article 4, as I'm going to take you to in a moment, and jurisdiction is conferred at the defendant's domicile. This has, in my submission, important implications for when other rules of the other jurisdictional rules of the regulation are engaged through Article 5 of the regulation, and primarily at places other than the domicile. And I'll explain what I mean by that in a moment. Now, the relevant provisions for this proposition, first of all, we need to go to Recital 13. So I want to start with the recitals first, page 3. Recital 13 introduces the principle that one gateway into the regulation is domicile. It states there must be a connection between proceedings to which this regulation applies and the territory of the member states. Accordingly, common rules of jurisdiction should in principle apply when the defendant is domiciled in a member state. So that's the first gateway. Recital 14, which I'm going to come back to in expanding upon the second gateway, why that's important to distinguish, is concerned with situations where the defendant is not domiciled in a member state. And as I say, I'm going to come back to that gateway in a few moments. Recital 15 states the rules of jurisdiction should be highly predictable and founded on the principle that jurisdiction is generally based on the defendant's domicile. And it goes on to say, in my submission, this is quite important when one seeks to understand the scheme and intention behind the regulation. Jurisdiction should always, and I emphasize always, be available on this ground, save in a few well-defined situations in which the subject matter of the dispute, and that is obviously a reference to Article 24, which I'll come on to, or the autonomy of the parties warrants a different connecting factor. Now,
why isn't that directly in
The
point
autonomy
here?
of the
the autonomy of the parties is in point, but what your lordships and your ladyship are perhaps putting to me is that the autonomy of the parties there refers to everything in Article 25, whereas my position is that it only is dealing with an exclusive jurisdiction clause because, and I'll come on to this when I get to the POCAR report, but I know that the court is anxious to understand the argument, because that from a regulation perspective, the function of a non-exclusive jurisdiction clause is to confer jurisdiction by contractual autonomy at places other than conferred under the regulation. So in my submission, and that's what the POCAR report says, which I'm going to come on to. So in my submission, when it emphasizes it should be always be available, it must always be available, save where party autonomy or subject matter displaces it. The question that one has to ask is, has there been an ouster? In the context of Article 24, subject matter jurisdiction, jurisdiction in rem and so on, as we're going to come on to, there is an ouster. The regulation hierarchy makes that clear. In the context of Article 25 and party autonomy, there's a deliberate split between exclusive and non-exclusive jurisdiction clauses. Exclusive do oust domicile, and we're going to see that. We're also going to see that a non-exclusive jurisdiction clause does not oust domicile. They have perfect parity within the scheme of the regulation. And as I say, the critical point is that it is intended to engage a jurisdiction where there is not existing jurisdiction under the regulation.
Does the regulation refer anywhere else to non-exclusive jurisdiction? I mean, it doesn't actually refer to it because it says it shall be exclusive unless the parties agree otherwise. But that's the only place, that sentence is the only place, as far as I'm aware, where that point is made at all. And the previous sentence says that where the parties have agreed to courts of member state are to have jurisdiction, that court shall have jurisdiction. And that sentence doesn't draw any distinction between exclusive and non-exclusive.
It doesn't draw a distinction, but what it doesn't tell you is what does party autonomy mean, and does party autonomy mean that in the context of non-exclusive jurisdiction clause, the function of which as a matter of the regulation is to extend jurisdiction where it doesn't exist as a matter of the regulation.
Well, that may be the critical point. I mean, the other way of looking at it, which no doubt Ms Dilnot will seek to persuade us, is that it's saying, irrespective of domicile, the court shall have jurisdiction.
Well, that this is what I submit is the overemphasis on the term shall, which in the French text, for example, it uses the verb être, to be, i.e. is. And Article 4, the domicile...
The French text says that it's that court or courts are competent, doesn't it? Which means...
Are and is, yes, être, from the verb
are
être.
competent.
Yes. And
Sont compétentes.
Yes, sont and est competent is sont competent.
Well, the important word is competent, not the,
yes,
not the is.
What it means is shall have jurisdiction.
Well, but my lord, Article 4 equally uses the word shall.
Well, I mean, we don't want to get hung up doing mandatory or non-mandatory uses
That's my
of
point.
verbs.
We should.
It's the substance that matters, and surely the point being made. I mean, the important word is autonomy. It means the parties are given a free hand.
Yes, my lord.
To agree, and what they've agreed in this case is to submit. I mean, there's no purposive interpretation one needs. It's perfectly obvious what they've agreed, which is that there is to be submission to the jurisdiction of the English courts.
Well, I don't accept that, my lord.
All right. I mean, I'm puzzled. Well, no doubt you'll explain why.
I know your lordship is puzzled, but I have to take it in stages because we are concerned with the scheme. We've so far managed to get to Recital 15,
yes,
and the fact that jurisdiction should always, my point from it is, should always be available, save in well-defined situations relating to subject matter or party autonomy. So the point I derive from that for the present purposes is that there has to be an ouster. So if the court accepts Ness's argument...
You get to this extraordinary conundrum, which your case doesn't answer, it seems to me. That if the defendant had been domiciled in France, then Article 33 would simply be out of the question, because you use jurisdiction under Article 25, full stop. Because the defendant's domiciled in England, as well as the claimant domiciled in England, you can somehow get into Article 33. It just makes no sense whatsoever.
Well,
it's a point the judge made at some point in his incredibly
understand.
complex judgment. He does actually make that point.
I can understand why, from an English domestic forum non-convenience perspective, you would take...
No, it's got nothing to do with forum non-convenience.
Well,
it's to do with party autonomy, as my lord just put to you.
Let me proceed with the argument and see if I can shake you from the proposition.
No, that's why you're here, Mr. Dewar.
Yes, I mean, party autonomy is one of the guiding lights which shines through recitals as something which is to be given a privileged position. Well, I mean, that's all it boils down to.
But it depends on what party
and
autonomy...
they've extended it, because previously it only applied where in more limited circumstances, under the old Article 17 as was.
Which was only exclusive.
And now they've got a much wider...
But there's a difference which has to be grappled with between an exclusive and non-exclusive jurisdiction clause and where the non-exclusive fits in within the scheme. And I still need to get you to where I am on that, which I haven't yet got there.
I'm afraid we've been firing salvos at you.
No, not at all. I understand the issue that I have to grapple with, but I'm determined to grapple with it because I have belief in the point. So, Article 4... So I've made the point that that what I say is the effect of Recital 15 is that domicile should always be available unless there's an ouster. That's what I say. And the question, therefore, is whether there's been an ouster by party autonomy in the context of a non-exclusive jurisdiction clause. That's really where the nub of the point is, and that's where, at the moment, the court is very, very far away from my position. Now, Recital 16 is important in this context, which is, in addition to the defendant's domicile, there should be alternative grounds of jurisdiction based on a close connection between the court and the action. Now, and then it goes on to say the existence of close connection should ensure legal certainty and avoid the possibility of the defendant being sued in a court of a member state which he could not reasonably have foreseen. Now, I emphasize the in addition, which means that in addition to domicile, there are alternative places of jurisdiction. And what it means by that are other courts, not the domiciliary court. So
Well, this is dealing with the things like special jurisdiction, Article 7, isn't it?
well, not just that one.
Not just that, but it's one of the things.
It's also dealing with Article 25. I'll explain how I get to that. So it's not just special jurisdiction. So if we go to now go to Article 4.
Right. So do you want any more of the recitals?
Not for the time being, though.
At the risk of irritating you, may I throw in Recital 19, the autonomy of the parties to a contract should be respected.
Yes, my lord. And in my submission, I will be respecting the autonomy of the parties as that proposition is understood under the regulation. But again, that's our point of difference, which I haven't yet grappled with.
Look, I know you're having to grapple with an awful lot that's being fired from the bench at the moment.
Yes.
But if one looks at paragraph 16, if you really do want to rely on it, isn't that phrase, which he could not reasonably have been foreseen, rather difficult for you? Because the whole purpose of the agreement is that the parties will foresee what could happen.
My lady, for my purposes, there's no difficulty with the reasonably foreseen in this sense. What Recital 16 is doing is explaining the scheme of the regulation. So you've got domiciliary jurisdiction as an entry gateway, and then you've got a number of other rules, which we're going to come on to. One of them being which can be reasonably foreseen at places other than the domicile. That's what it's dealing with, because it's dealing with, in addition, alternative grounds at places other than the domicile. So, of course, a non-exclusive jurisdiction clause gives a reasonably foreseen basis of jurisdiction. But what Recital 16 is dealing with is reasonably foreseen other than at the place of domicile, because that's how the scheme works. You enter through Article 4.
Yeah, I know how
Yes.
it works, thank you.
So,
Yeah, okay, all right. Anyway, you're going to show us Article 4.
Article 4. Apologies, my lady, if I laboured the point.
Article 4.
So, subject to this regulation, persons domiciled in a member state shall, and you'll see the word shall, which I say is a neutral point, whatever the nationality, be sued in the courts of that member state. Now, as the court is aware from the citations that I've given, the domiciliary jurisdictional rule has been variously described by the European Court and the Supreme Court in this jurisdiction as fundamental and a primary rule. And I'll just very briefly take you to the authorities on that. So in this volume, at tab 9, this is the Kynes Pantherwerker case, European Court of Justice case, and we only need to look at paragraph 21 on page 211. You'll see, starting from the third line, persons domiciled in a member state are to be sued in courts of that state, irrespective of the nationality of the parties, is only by way of derogation from that fundamental principle, attributing jurisdiction of the courts of the defendant's domicile, that Section 2 makes provision for certain special jurisdictional rules.
That's when Article 2 was what's now Article 4.
That's correct.
And Article 5 was well, it's still, it's Article 6 now, isn't it? Special jurisdiction. Article 7 rather.
Article 7.
7 rather.
And just onto the next tab, Vedanta, at page 225, paragraphs 29 and 30. Second line. The starting point is the need to recognise that following a Rousseau and Jackson, what is now Article 4.1 lays down the primary rule regulating jurisdiction of each member state to entertain claims against persons domiciled in that state. And then paragraph 30 goes on to describe, refers to it as the centrality of Article 4, and it refers to various European court decisions which have referred to the centrality of that provision. Now, going back to the regulation, and Article 5, persons domiciled in a member state may be sued in the courts of another member state only by virtue of the rules set out in sections 2 to 7 of this chapter. So that's Article 5.1. So what I submit, that obviously sections 2 to 7 obviously include Article 25. So it's not just the rules of special jurisdiction, but all of the various other heads, including prorogated jurisdiction under Article 25. Now, in other words, ordinarily, and that's why I described it as the primary position, you look to the other rules of where there is domiciliary jurisdiction, you look to the other rules of jurisdiction for conferring jurisdiction at a place other than the place of domicile. So to give you an example, if the place of performance of a contract is other than at the place of domicile, you can engage Article 7. If, in my submission, one does not engage Article 7 at the place of domicile, you've already got domiciliary jurisdiction, and the scheme of the regulation says you only need engage these rules at places other than domicile.
So is
Well,
your
that's what it says, though.
Yeah.
A person domiciled in a member state
So-
may be sued in another member
Right.
state.
So-
But that qualification doesn't appear in Article 25.
Well,
Article 25 doesn't touch upon, doesn't refer to where you're domiciled. It says that where there's we'll debate, no doubt, exclusive versus non-exclusive.
yes.
Where there's a jurisdiction clause providing for jurisdiction of the courts of a member state, that court shall have jurisdiction.
Well, again, I'll come on to
Brackets
the shall.
irrespective of domicile, I think.
Well,
is really the,
regardless of domicile.
well, regardless.
Now,
of
and the reason why it says regardless of domicile is important, my lord, because, and I'm going to come on to that, that's the secondary gateway. Well, one has to be careful about reading regardless of domicile as somehow meaning that where you've entered the regulation through what I've described as the primary gateway of domicile, that you can just superimpose Article 25 straight away without first passing through Article 4. Because the reason for the language of regardless of domicile is to do with Article 6 and Recital 14. That is, that there are certain rules of jurisdiction which are to be engaged even where there is no domicile. And the regardless of domicile language is used for that purpose, as I'm going to take you on to in the context of the secondary gateway. And that's quite important because in my submission, when one's in Article 4 situation, the primary position is you have to pass through Article 4 gateway because the defendant is domicile. You look under Article 5 to conferring jurisdiction at places other than the domicile through sections 2 to 7, but you can't go straight to Article 25 save in one situation which we're going to come on to.
The very first words of Article 4 are subject to this regulation. So, I mean, although it's a primary provision, it is one which is, from the very start, qualified.
Yes, subject to this regulation.
Isn't Article 25 part of this regulation?
It is, well, my lord, it is, but one still has to apply, it's subject to this regulation, which means it's equally subject to Article 5, and equally, therefore, subject to the fact that Article 5, in its primary position, says you look to rules, the other rules of jurisdiction.
The logic of your argument, Mr. Dewan, is that, well, it's one of the things, and maybe I'm jumping ahead, so I apologise, but the logic of your argument is your argument applies irrespective of whether the jurisdiction clause is exclusive or non-exclusive. Because you say, well, you come in, as it were, via domicile, so jurisdiction is based on Article 4, come what may.
The answer to that is that, as I said, this is the primary position, but as a matter of teleological interpretation and having respect for the scheme of the regulation, one has to import an exception into Article 5 and the application of the other rules other than at the place of domicile, where there is ouster, because this goes back into whether domiciliary jurisdiction remains available.
But on your case, let's assume this was an exclusive jurisdiction clause.
Yes, ma'am.
There isn't an ouster because the court has jurisdiction anyway as a result of Article 4. And if, as you say, Article 25 is somehow subsidiary to Article 4, I don't understand the difference you draw between an exclusive and a non-exclusive jurisdiction.
Apologies, my lord, for the confusion I'm creating. But there's a difference between entering the regulation through the gateway of Article 4 and whether jurisdiction is then conferred. It has a dual purpose. One is, what are the rules applicable as a matter of jurisdiction where domiciliary jurisdiction exists and where it doesn't exist? So in the situation...
Sorry, just repeat that. Difference between entering the gateway through Article 4 and what?
So there's a difference between... There are two gateways into the regulation. The first is where domiciliary jurisdiction exists, and then there are various rules that apply, and then there's the secondary gateway where domiciliary doesn't exist, and then there's various jurisdictional rules apply. In the first situation, what your lordship is putting to me is that, well, on your argument, it makes no difference whether it's exclusive or non-exclusive. My answer to that is it does make a difference in this sense. You're still entering the regulation through Article 4 because domiciliary jurisdiction exists, and therefore Article 4 and Article 5 apply, but as a matter of teleological interpretation of Article 5, although the primary rule is that you only use the other rules of jurisdiction at places other than domicile, in the case of an exclusive jurisdiction clause, domiciliary jurisdiction no longer actually confers jurisdiction, because in the sense that it is trumped by a superior rule. So although it exists, it's trumped. So I could not say in the case of an exclusive jurisdiction clause that jurisdiction is based on domicile at the place of domicile for the purpose of Article 33, because it's trumped by a superior rule. And the question is whether a non-exclusive jurisdiction clause is such a superior rule. So just coming back to where I was, in the context of Article 7 jurisdiction, in my submission, one would not apply, if the place of performance of the contract is England, so it's not at a place other than domiciliary jurisdiction, one would not talk about having Article 7 jurisdiction. Because you've already got domiciliary jurisdiction. And Article 5 is telling you to apply these rules at places other than the domicile. Now,
Is there any authority for your particular teleological or purposive, I think is a more English word, construction of Article 5 in relation to exclusive jurisdiction clauses?
There's no authority, but there's equally no authority the other way. There's no authority cited to the court to the effect that you apply any of the rules of jurisdiction other than out where there's domiciliary jurisdiction, places at the domicile. There's no this concept, as I've said, there's no this concept of this concurrent jurisdiction at the same place. I don't accept exists within the scheme of the regulation. You can have concurrent jurisdiction at different places, but not within the same. What happens where you have an exclusive jurisdiction under Article 24 or an exclusive jurisdiction clause under Article 25 is that the domiciliary jurisdiction, albeit the entry point into the regulation, is subject to a superior rule such that in substance it's no longer available. Now, I do now need to go into the secondary gate.
Article 24 is dealing with things like rights in rem and land.
Yes.
And it provides that the courts of the member state shall have exclusive jurisdiction regardless of domicile.
Yes.
So if this were an Article 24 case, which concerned English
Yes.
land, for example,
Yes.
Then Article 24 would apply, and you wouldn't get anywhere near Article 33.
Yes, my lord, but the route by which that conclusion is arrived at is important. I say that if the defendant is domiciled in this jurisdiction and the land is located in this jurisdiction, you still go through Article 4, but you have to read, because of the fact that the defendant is domiciled, and that's the difference between Article 4 and Article 6.
Well, the question is how much of Article 4 you have to go through. I mean, the important words, it seems to me, are the opening ones, subject to this regulation. So you go to Article 4, and you then find elsewhere in the regulation Article 24, which is directly in point.
Well, except that I say that's subject to Article 5.
Well, Article 5 is in a sense, there's a tension in it, which is why you have to give it a purposive construction. Persons domiciled in a member state may, not must. So it doesn't actually, in one sense, it doesn't deal with Article 24 properly at all, or indeed Article 25 for that matter. So it's a slightly loose use of language. May be sued in the courts of another member state.
Well,
So on one view, Article 5 isn't really dealing with this case at all.
Well, in my submission, that's what your lordship's putting to me. In my submission, it is, because it's the general scheme of how the regulation fits in. But
Well, because you're not being sued in the courts of another member state. You're being sued in the courts of the same state as the state of domicile.
Yes, ma'am.
But by reason of a different provision, and as my lord says, it's subject to this regulation.
Well,
So you look at the regulation, and then what you say is, well, if it's Article 24, there's exclusive jurisdiction. If it's Article 25, irrespective of whether it's exclusive or not, the chosen court shall have jurisdiction.
well, can I go to the secondary gateway and then try and bring all of this together?
Yeah.
Now, the secondary gateway is, if we go back to Recital 14, on page 3, a defendant not domiciled in a member state should in general be subject to the national rules of jurisdiction applicable in the territory of the member state of the court seized. So in general, where the defendant is not domiciled, you don't apply the regulation. But in order to ensure the protection of consumers and employers, to safeguard the jurisdiction of the courts of the member states in situations where they have exclusive jurisdiction, and to respect the autonomy of the parties, certain rules of jurisdiction in this regulation should apply regardless of the defendant's domicile. And when it says regardless of, which the court has placed emphasis to me in my submission, which the court is not with me at the moment on, is that it's talking about situations where the defendant is not domiciled. The regardless of domicile is not saying that even where there is domicile, it's i.e. where there is no domicile, and I take that from the opening of Recital 14 and also Article 6.1. So Article 6.1 says, if the defendant is not domiciled in a member state, the jurisdiction of the courts of each member state shall, and then it gives the ones which apply. So where the defendant is not domiciled, you can go through what I've described as the secondary gateway and directly apply these provisions. Article 18 is dealing with consumers, Article 21 is dealing with employment contracts, Article 24, as we know, is dealing with in rem rights, and Article 25 is dealing with exclusive and non-exclusive jurisdiction clauses. So in my submission, that's why I said at the beginning it's quite important to distinguish between the two gateways to the application of the regulation. In my submission, under the scheme, one cannot simply skip over Article 4 to other jurisdictional rules and import them at the place of domicile. The scheme of the regulation is set up such that you apply domicile at the place of domicile, you apply other rules of jurisdiction elsewhere, subject to ouster, because that's consistent with the intention of the regulation, which is that domicile should always be available subject to certain limited exceptions based on subject matter or party autonomy. So,
I'm sorry, Mr. Stephen, it's probably me, but what is the secondary gateway you're talking about? Which is the secondary
where there's
gateway?
no domicile, Mike. Where there is no domicile, then you, under Recital 14, read with Article 6, you can apply certain jurisdictional rules straight away. These are not dependent on there being domiciliary jurisdiction. And that's why it uses the regardless of domicile language. So that's why, my Lord...
So how does this work? So let's assume, just a standard case, the defendant's domiciled in France, but the case is the English court is seized with the case.
By reason of a jurisdiction clause?
No, just generally. Jurisdiction of the courts of each member state shall, and forget the subject to for the moment, be determined by the law of that member state. So, how does that work?
My Lord, my Lord, the answer to that is in Article 5. So, in this situation which your Lordship has been positing to me, France is the domicile, and the question is whether, if an attempt is made to bring a claim here, whether any of the rules under sections 2 to 7 apply. It won't be national rules, it'll be because you're going through the gateway of Article 4 in that situation, because there is a domiciliary jurisdiction. So what happens is you have to ask whether in England there is a jurisdictional rule which can apply in sections 2 to 7.
Well, I'm still not following what the situation is in which Article 6.1 applies.
The answer is Article 6.1 applies where there is no domiciliary jurisdiction. The defendant is not domiciled in a member state. Certain rules can be applied directly.
So this is dealing with a situation where the defendant's, for example, domiciled in the United States of America.
Or all of the examples that have been put to the court on the application of Article 25 and its interaction with Article 33 are all situations where there was no domiciliary jurisdiction, and the non-exclusive jurisdiction clause was therefore applied through the gateway of Article 6. Because the defendant was, in UCP, the defendant was domiciled in Cyprus. In the other case, in Nigeria, in the other case, Saudi Arabia.
Okay. So this is really a carving out the case where the convention doesn't apply at all because the defendant isn't domiciled in a member state.
Correct.
So it's not really convention jurisdiction at all.
It's an extension. It's an extension. But what's important, my lord, and why I emphasise that is because the court is putting to me that the regardless of domicile language in Articles 24 and 25 is important. And in my submission, when it uses the words regardless of domicile, that tracks Recital 14, the regardless of domicile. And what Recital 14 and Article 6 are making clear is that the regardless of domicile language is language to convey the fact that these can apply where there is no domiciliary jurisdiction. Not that regardless of domicile language somehow of itself ousts domicile. That's the way I would put it. And I accept that I still have this additional hurdle which is troubling the court on party autonomy, and I'm coming to it as best as I can.
Well, subject to Articles 24 and 25, for example. So if you can found jurisdiction against a non-member state domiciled defendant, if, for example, you get yourself within Article 24, because it concerns English land.
That's correct. My lord, forgive me if I've said something inconsistent with that, but that's my...
Okay.
Now, so then we get to Article 25, which, on my case, we have entered the regulation through Article 4. One cannot just directly apply Article 25 under my interpretation of the scheme, because ordinarily you apply these other rules, sections 2 to 7, at places other than the place of domicile, which I say is subject to a caveat where domiciliary jurisdiction has been ousted, because that fits within the scheme of the regulation. And I do emphasize again, before I get into the language of Article 25, that on my case, one never talks of there being jurisdiction under Article 4 and, for example, Article 7. It's one or the other. So if the defendant is domiciled in this jurisdiction, the fact that the place of performance is also in this jurisdiction is neither here nor there. Jurisdiction is based on Article 4. Because there's nothing, that's the effect of Articles 4 and 5, and there's no ouster. Article 7 is not a superior rule to Article 4, and it would simply be Article 4. There's no concurrent jurisdiction. So that then brings us to Article 25 and the question of trumping or ouster. Now, my first point is that one cannot place, in this context, weight on the words regardless of domicile as meaning that that is an ouster, or meaning that all of Article 25 is superior. That's for the reasons I've already given, which is that language was deliberate and drafted to make it clear that this provision applies even where the defendant is not domiciled in a member state, not for any other purpose of superiority or ouster. That's my first point. The second point is the weight that is placed on the word shall. Now, one has to, in my submission, the word shall is a neutral term and doesn't of itself import that it's intended to be mandatory or ousting in and of itself. Article.
How does that work? Because this convention uses the word may in relation, for example, to Article 7, which clearly is discretionary.
Well,
The word shall normally is a matter of normal language, whether it's purposive according to the regulation or something else, is a mandatory word.
Well, my lord, if that were the case, then they would.
After all, Article 4 uses the word shall, and according to you, Article 4 is the, as it were, the kingpin.
Well, but then.
So why does shall mean something different in 25 to what it means in 4?
But that's the problem, my lord. You've got two shalls. Why is one shall superior to the other shall?
Well, because as my lord pointed out to you, Article 4 begins with subject to this regulation.
Well, that depends on, but subject to this regulation in my respectful submission is a slightly circular way of looking at it, because then it depends on whether something outs domicile.
Excuse me, that's not circular. That's construing them two together in a hierarchy.
What? Apologies, my lord. I didn't mean it with any disrespect at all.
I still don't get, no doubt you're going to tell us, but I still don't get how you get to ouster with exclusive jurisdiction clauses, but not with non-exclusive.
Yes,
clauses.
my lord. I'm coming there.
If shall's neutral, as you say.
Shall is neutral in my submission. I do rely on the shall in Article 4 as well to support the fact that it's neutral.
What do you mean by neutral? You mean it really means may? Or, I mean, I don't
It
understand.
has jurisdiction. There is jurisdiction under Article 25. It doesn't mean it's a superior jurisdiction.
Well, I thought all these courts. You know,
So even though there's no domicile, regardless of domicile, meaning even though there is no domiciliary jurisdiction, even though there is no domicile, the court has jurisdiction. It's not mandatory. That doesn't mean it must take jurisdiction. It has jurisdiction.
well, if you like, it's declaratory of a result which the regulation brings about. I mean, isn't this really just an exercise in linguistic logic shopping? I mean, because the whole purpose is to confer a priority on that jurisdiction in the position covered by Article 25.
Can we put it this way, my lord? The shall in Article 25 doesn't trump Article 24. The court would accept that because Article 24 is a superior rule. And let me explain how. So, under Article 24, when it says the court shall have exclusive jurisdiction, the critical word in my submission is the fact that it says exclusive jurisdiction, not the shall. And of course, it's got the regardless of domicile language because of the fact that it applies even where the defendant is not domiciled. And the meaning of exclusive jurisdiction in terms of the hierarchy of rules is explained in Article 27, where it says, where a court of a member state is seized of a claim which is principally concerned with matters over which the courts of a member state have exclusive jurisdiction, by virtue of Article 24, it shall declare of its own motion that it has no jurisdiction. So, as was the argument at first instance, and was accepted at least this much, Article 24 is, to use Mr Houseman's words, top dog. So, the shall in Article 25, as my learned friend also accepts, is still subject to rules which are superior to Article 25. And that's why I submit the emphasis shouldn't be on the shall as opposed to the nature of the jurisdiction conferred. And in the final sentence of Article 25, it says such jurisdiction shall be exclusive unless the parties have agreed otherwise. So So the jurisdiction is to be exclusive unless the parties agreed otherwise, i.e. if the parties have agreed non-exclusive jurisdiction. Now, I did mention, and your lordship has already picked up on the French text uses the verb être rather than devoir, which is the French for shall. I do place at least a small amount of emphasis on the fact that it's using the verb to be, so it has jurisdiction as opposed to shall in a mandatory sense. Now, in the case of a non-exclusive jurisdiction clause, from a regulation perspective, in my submission, we need to look at the Etihad case, which is in volume 2, tab 12.
It is incidentally now reported in the week's law reports.
Apologies.
A couple of weeks. Don't apologise, but just for reference, about 2 weeks ago.
Thank you very much. The relevant paragraph is 61 and 62 on pages 345 and 346. As Lord Justice Henderson knows all too well, given that this is his lordship's judgment, this is a case concerning an asymmetric exclusive jurisdiction clause. What is relevant for my purposes is the reference here to the POCAR report on the Lugano Convention, which Lord Justice Henderson accepted would provide as providing an authoritative explanation of how the wording of what is now Article 25 achieved its present form, and that's a paragraph 62. Now, the bit on the POCAR report that I rely on is the bit quoted here, which is quoted in full. I've put the POCAR report in just for the court's reference, but we don't need more than what's here. It says the 1988 Convention lays down that a prorogation clause that meets the requirements of the Convention always confers exclusive jurisdiction on the designated court or courts. But under the laws of some of the states bound by the Convention, under English law in particular, the parties will often agree a choice of forum clause on a non-exclusive basis, leaving other courts with concurrent jurisdiction, and I emphasize the word other courts, and permitting the plaintiff to choose between several forums. And English law has accepted that a non-exclusive clause constitutes a valid choice of forum under the Convention. On a proposal from the United Kingdom delegation, the ad hoc working party re-examined the question of the exclusive effect of a choice of forum clause and reached the conclusion that since a clause conferring jurisdiction was the outcome of an agreement between the parties, there was no reason to restrict the parties' freedom by prohibiting them from agreeing in the contract between them that a non-exclusive forum should be available in addition to the forum of forums objectively available under the Convention. And it's that last 3 lines that I do place emphasis on, because in my submission what it's saying is, first of all, a non-exclusive jurisdiction clause is not something which was that familiar to many member states. Secondly, on a regulation basis, from a regulation perspective, what the intention was that it should confer a non-exclusive jurisdiction, should confer jurisdiction at places that don't otherwise exist under the regulation. It's a form of extension or prorogated jurisdiction. And so that's why I submit that where you have domiciliary jurisdiction under Article 4, a non-exclusive jurisdiction clause from a regulation perspective is not an expression of autonomy in any relevant sense, because all it's doing is doubling up on the jurisdiction that already exists. So from a regulation perspective, it doesn't extend the jurisdiction that already exists, and it certainly does not oust it. And let me make that proposition good, if I may. If we go back to volume 1 of the authorities bundle, tab 7, there's some various extracts from David Joseph QC's book, which I want to take the court to. If we could start, so this is tab 7 of volume 1, page 174. So the first bit is at on page 174, paragraph 4, which says, begins, if parties have concluded a non-exclusive jurisdiction agreement. He says, what he says is, then the parties will have conferred jurisdiction on the identified court or courts in addition to the courts that have jurisdiction by virtue of the application of the general rule regarding domicile and the special jurisdiction provisions. I emphasize the words in addition, in the same way that it was emphasized in my submission. That's what the POCAR report is saying. If we then go on to page 176, paragraph 3.15, and it's the last two full sentences starting, however, where parties have agreed that an identified court or courts shall have non-exclusive jurisdiction, this does not oust the substantive jurisdiction of other courts under the provisions of Brussels I regulation recast. By way of example, and this is important, parties who have agreed that the English court shall have non-exclusive jurisdiction do not oust the substantive jurisdiction of the courts of the domicile so long as that court is first seized. So let me just unpick that a little bit. In the case of an exclusive jurisdiction clause, which is second in the hierarchy, well, third in the hierarchy actually, but it's below Article 24. The reason why exclusive jurisdiction has a superior hierarchy is explained by Article 31.2 of the regulation, which Lord Justice Henderson referred to in the Etihad case. So 31.2, which applies to exclusive jurisdiction clauses, this is, sorry, tab 1, page 12. Without prejudice to Article 26, that's entering an appearance to contest the merits. Where a court of a member state on which an agreement as referred to in Article 25 confers exclusive jurisdiction, any court of another member state shall stay the proceedings until such time as the court seized declares it has no jurisdiction. That's what happens with a 31, with an exclusive jurisdiction clause. So everyone else has to give up. With a non-exclusive jurisdiction clause, the reason why Mr. Joseph's book explains that there's no ouster is the relevant rule is Article 29, which is the first seized rule. So, in other words, if you have domiciliary jurisdiction in this jurisdiction, you have non-exclusive jurisdiction in France, the jurisdiction which will win, as in retains jurisdiction, is the one which is first seized, because they are in parity. So that's why Mr. Joseph says in his last sentence that we just looked at, an English court, where you have non-exclusive jurisdiction, it doesn't oust the substantive jurisdiction of the courts of the domicile of the putative defendant so long as that court is first seized, because they are on parity, and the way that the regulation deals with tiebreaker situations is Article 29, and it's first seized. So it would equally be if the in the converse situation where the non-exclusive jurisdiction clause is engaged first, then it would win. But that doesn't tell you anything about their superiority. It just shows that they're on a par within the scheme of the regulation, in my submission. So going back to Mr. Joseph QC's text, we've looked at 3.15. There's one other paragraph that I...
But the point he's making in the next paragraph, 3.16, as I understand it, is this, isn't it? And this is all member state based, so where both parties are in member states, so we're not actually in this territory at all, because we're concerned with where the courts in question are member state courts, and you're dealing with issues between which is the court first sees, which is the court second sees. Here we've got a court in the United States of America, which isn't a member state. But Article 29(1), what the point that Mr. Joseph is making in paragraph 3.16 is, if as a consequence of a non-exclusive jurisdiction clause, the English court has jurisdiction by virtue of Article 25, and if the English court is first seized, then under Article 29, other courts have to give way.
Yes, but my lord...
And 31(2), of course, isn't relevant there because it's not another court.
But my lord, the point for my purposes is that I put to the court, my submission is that where you have domiciliary jurisdiction, the gateway to the other, as the gateway into the regulation, you apply the other rules at places other than the domicile unless it's ousted and therefore no longer available. What I draw from the scheme that I've taken the court to, Article 29, Article 31 and Article 27, is that a non-exclusive, and also having regard to the function of a non-exclusive jurisdiction clause, which is a separate point, there is no ouster within the scheme of the regulation. There is no priority given to a non-exclusive jurisdiction clause as compared with domiciliary jurisdiction. So the notion that as a function of party autonomy, one goes straight to Article 25 and says that that is an expression of party autonomy and therefore it effectively trumps domiciliary jurisdiction. In my submission, that's inconsistent with the scheme, which puts them on a par. I also say, as a separate point, it's also inconsistent with the function under the regulation of a non-exclusive jurisdiction clause, which is to confer jurisdiction at places where that jurisdiction does not exist. So in other words, since domiciliary jurisdiction exists in this jurisdiction, since non-exclusive jurisdiction is not a superior rule and doesn't oust it, it actually serves no function. That's why I say it's irrelevant at the place of domicile, because it serves no regulation function. The additional passage that I rely on from Mr. Joseph QC's book is at page 184, paragraph 10.77. My Lord, before I take you to the relevant passage, I would also emphasize the point which is made in the POCAR report and is also made by Briggs, Professor Briggs, which is that this concept of a non-exclusive jurisdiction clause is not familiar to all member states, but one has to apply it uniformly across all member states who may be faced with such a clause. Now, 10.77, page 184, reading from the last two sentences starting nevertheless. He essentially is repeating the point that we've seen before. There's an important difference between exclusive and non-exclusive jurisdiction agreements. In the case of the former, the parties have agreed to bring their disputes before an identified court and no other. This is not the case in relation to a non-exclusive jurisdiction agreement. Indeed, as a matter of community law, the non-exclusive jurisdiction is simply treated as making provision for additional jurisdiction. So,
I'm slightly puzzled as to why the learned author said it's not altogether easy to see why that mandatory jurisdiction ought to be displaced, when on the face of it, that is the clear effect of Article 25, read with the very first words of Article 4, which I've already referred to.
well,
I mean, surely, and it may not, they may not, as a, so to speak, species of commercial clause, exist in many member states, but the concept is not one that requires any sophistication to explain. Is it?
well,
It's just it's a simple agreement that you will agree to submit to the courts of a particular state, but without prejudice to other possibilities which may be open to the parties.
my lord, I entirely accept that that is how one would interpret that as a matter of English law.
Why is that?
But,
I mean, it's just.
but,
sorry.
no, my lord.
The way it works is this, isn't it? That for the purposes of the position between the courts of member states, it's only if the jurisdiction clause is exclusive that you can, as it were, get over the fact that if the court first has jurisdiction under the convention, then other courts have to give way, and that would include, for example, if the French court had jurisdiction under the special jurisdiction provisions, Article 7 or whatever, then irrespective of the existence of the non-exclusive jurisdiction clause in this contract, the English court would have to give way under Article 29 because the French court is properly seized and first seized. Another way of looking at it is to say, well, the parties always contemplated that possibility given that they entered into a non-exclusive jurisdiction agreement. They always contemplated that if you could get another court in another member state properly seized of the dispute, then hard luck, as it were. But what none of that deals with is the position we're dealing with here, which is the position between courts of a member state on the one hand and courts of a third state which isn't a member of or isn't a signatory of the regulation, and that's dealt with in Article 33.
Yes, my lord. But the question, that of course is right as to the question of when do you apply the lis pendens rule. But the question is whether jurisdiction is based on Article 4 for the purposes of Article 33. And in my submission, when one looks at the scheme of the regulation, having regard to the fact that one's entered through Article 4, having regard to the fact that under the scheme of the regulation, a non-exclusive jurisdiction clause is not superior to domicile, and having regard to the fact the function of a non-exclusive jurisdiction clause, which is to provide extend jurisdiction to places which do not exist objectively under the regulation. When you have regard to those 3 points, then in my submission, at the place of domicile, jurisdiction is based on domicile, not non-exclusive jurisdiction.
Right.
My lord, if I may move on to my next point on this, which is the case law. Obviously, there is no case which has addressed this situation where at the same place there is domiciliary jurisdiction and non-exclusive contractual jurisdiction. There is no case either in this jurisdiction, and as far as I'm aware, and I think my learned friend is aware, in any other EU jurisdiction. Now, so the cases that my learned friend places reliance on, like the judge did, is first of all the UCP case, which is at volume 2, tab 19. Now, what is relied on is at page 531, paragraph 41. Apologies, I should have given the court the facts. So what we have is a Isle of Man company, i.e. non-EU domiciled company, suing a Cypriot company, i.e. non-EU domiciled, before the English court, pursuant to a non-exclusive English court jurisdiction clause, and you can see that from paragraph 7.
Mm-hmm.
With the non-exclusive jurisdiction clause set out in paragraph 8. And what was held at paragraph 41 is that, well, you can't engage, therefore, articles 33 or 34 because they don't mention article 25 jurisdiction. That's at paragraph 41. Now, for my purposes, the critical distinction is that in my submission, when I was entering the regulation through the secondary gateway through Article 6, because the defendant was not domiciled in the regulation, in a regulation state, and through Article 6 you can directly apply Article 25 as it provides, including non-exclusive jurisdiction, and therefore jurisdiction is based on Article 25, not Article 4. So in my submission, this case and this line of cases is not inconsistent with my case because it's dealing with a different situation where you're entering the regulation through what I describe as the secondary gateway. My lady, my lords, I'm a little bit concerned about timing because obviously I have to get onto the second ground. So with the court's indulgence, I'm just going to try and keep certain points fairly short so that there's enough time to deal with ground 2. Now, so I've dealt with the main case. The other cases relied upon, I'm not going to take you to directly, but I'm just going to give you the citations. The City Core case at volume 3, tab 25. And again, it's the same point of distinction, which is that the defendants were both domiciled in the Kingdom of the Saudi Arabia. That's at paragraph 6. So you were not concerned with the situation we are concerned with in my submission. And the other case is the IMA against Capital Oil case, which is at volume 3, tab 24.
That's Mr. Justice Popperwell.
It is, my lord. So Ness relies on paragraph 44, well, 43 to 45, or rather 43 to 44. My critical point of distinction is at paragraph 1 of the judgment, which is that the defendant was a Nigerian company. So you're entering through Article 6.
Okay.
Now there's a passage from Briggs on which my learned friend also relies upon, which is at volume 1, tab 5. And there are two passages. The first is at page 155. So 155 under 2.292. So volume 1, tab 5, page 155, under the heading 2.292. The first paragraph, the last sentence. It would appear that the court will have no power under Article 33 to stay proceedings if jurisdiction is derived from Section 5, Section 5 being Article 25, prorogated jurisdiction. This may or may not be a desirable answer, but is an answer. But in my submission, that doesn't take the point much further, because that still begs the question as to whether a non-exclusive jurisdiction clause is in fact engaged at the domicile, at the place of domicile. The other passage that my learned friend relies upon is at page 136, C to E.
One what?
Apologies. Page 136, C to E. This is the hierarchy of jurisdictional rules. And the bit which my learned friend relies upon in particular is questions 8 and question 9. So question 8, has there been an agreement in prescribed form that a court or the courts of a member state ought to have jurisdiction? If the answer is that there has been, then Article 25 provides that the court has exclusive jurisdiction unless the parties agree otherwise. And then the next question, does the defendant have domicile in the United Kingdom? So reliance is placed on here by the fact that in these questions, Article 25 is placed above Article 4. I have two criticisms of this. The first is question 8 doesn't actually answer what happens where there's a non-exclusive jurisdiction clause. And as we've already seen, even within the scheme of the regulation, forget about third states. A non-exclusive jurisdiction clause, it does refer to it, but it doesn't deal with it. A non-exclusive jurisdiction clause has no hierarchical superiority to Article 4 jurisdiction. So this is perhaps a useful rule of thumb, but it's not dealing with the specific issue of the hierarchy between a non-exclusive jurisdiction clause and domiciliary jurisdiction. The other the other point is that this is just a general approach. It's not actually dealing with the gateways into the regulation, which in my submission, as I've said, makes a significant difference. Now, the other point, there's two other points that I need to turn on to, two small points. And then I need to go to deal with ground 2. The first is that the point is made that if jurisdiction is based on Articles 7 and 9, as well as non-exclusive jurisdiction, then jurisdiction is no longer based on Articles 7 to 9 for the purposes of Article 33, and the same logic should apply to Article 4. That's what's said. Now, in my submission, that really begs the question which this court is grappling with, because that assumes that the answer is that where you have Article 7 jurisdiction and a non-exclusive jurisdiction clause, the jurisdiction is based on the non-exclusive jurisdiction clause. And I don't accept that, because as the POCAR report states, the purpose of a non-exclusive jurisdiction clause is to confer jurisdiction at places which are not objectively available under the regulation. So, if you have got Article 7 jurisdiction, a non-exclusive jurisdiction clause conferring jurisdiction at the Article 7 place serves no regulation function, and jurisdiction remains based on Article 7. There is a further separate point of distinction, of course, between Article 4 and any of the other rules, because you enter the regulation, as I put it, through domiciliary jurisdiction. So that is different to these other situations in any event. The other and final point which is relied upon is Recital 24 in Volume 1, Tab 1, page 4. Now, these are the types of things that the court is to have regard to for the purpose of the administration of justice if you're in Article 33, if the court may recall. And what's relied upon is the fact that in the very last paragraph it says the assessment may also include consideration of the question whether the court of the third state has exclusive jurisdiction in the particular case and circumstances where a court of a member state would have exclusive jurisdiction. So what's said is that this must mean that Article 33 does not apply when Article 25 agreement exists, because otherwise you would have included a non-exclusive jurisdiction clause as a factor at the second stage in the administration of justice. Now, just to be clear, I don't accept that where it refers to exclusive jurisdiction, that's a reference to an exclusive jurisdiction clause, for a start.
It's dealing with Article 24.
It is, my lord. That's my primary first.
It's not a relevant. I mean, it's a much better point that's taken against you, but that one I think is perhaps. I mean, it's one of the problems that Briggs actually identifies, doesn't he? At some point, he says you've got to be careful when it talks about exclusive jurisdiction, because this is it actually is referring to two completely different concepts.
So.
Yeah.
I mean, there are other points I was going to make, but I think I'll move on from that.
Yeah.
My lord, we're therefore into ground 2.
Mm-hmm. Why don't all the circumstances of the case include the fact that there's a non-exclusive jurisdiction clause in favour of England?
Well, that's what's said. I don't accept it, and I'll come on to why.
Well, that's the question you've got to grapple with.
It is my lord.
It's as short as that, isn't it?
Well, yes.
If you say such circumstances may include, in your cases, such circumstances only include and don't include anything to do with the fact that there's a non-exclusive jurisdiction clause the other way.
Because once you've concluded that it's not engaged at the place of domicile because its function is not served, it's completely irrelevant.
So your agreement is completely irrelevant. The fact that you've irrevocably submitted to the English jurisdiction is to be completely ignored.
Yes, my lord.
When considering what is in the interests of the administration of justice.
Yes, and that is a difference between the administration of justice test under Article 33 and a forum non-convenience test under English domestic law, which I'm going to come on to.
It's got nothing to do with forum non-convenience. It's to do with the bargain autonomy of the parties, which is one of the things that this regulation seeks to uphold.
Perhaps, my lord, but I will be putting to the court that the administration of justice test is not concerned with factors of this nature that are said to point to this jurisdiction. But I'm going to have to take this in stages again. What we submit is that the administration of justice test is focused on the risk of irreconcilable judgments and any other matters going to the administration of justice in the third state, and that has been converted in my respectable submission into a domestic forum non-convenience test. And we know that as a matter of domestic forum non-convenience test in this jurisdiction, the existence of a non-exclusive jurisdiction clause is a powerful factor, but I submit that is not relevant under the regulation. Now, in terms of the scheme of Article 33, which is Volume 1, Tab 1, page 13, in my submission, there is a two-stage test to the administration of justice under Article 33. The first stage, which is not to be overlooked, is contained in Article 33(1) itself. Article 33(1) contains what's commonly known as the triple identity test. It's the same test that is to be found in Article 29 of the regulation in circumstances where there is lis pendens between member states. Triple identity meaning the same parties, the same cause of action and same object, i.e. the same fact, same rule of law and the same end in view. That is the, so you'll see Article 33(1).
Sorry, the same party is the same cause of action.
The same party, same cause of action, and same object. That's how it's described.
Same object.
Same
Where's the
object, meaning the same fact, same rule of law, and the same end in view. I'll take you to a European Court decision on this. But you'll see that it's the same. Article 33(1) contains the same test as in Article 29(1).
Mm-hmm.
There's of course a difference, and I'm coming on to that, but now it's important to understand why the 33(1) test is there. Where you have satisfied that triple identity, in my submission, you've created a prima facie case in the administration of justice that there should be a stay. Now, the reason why how I derive this proposition is as follows. First of all, if we go to Volume 2, Tab 20, this is a European Court decision known as the Tatry. Now, just to be clear, this is dealing with Article 29, not Article 33. But for present purposes, it is relevant. And if we go to paragraph 32 on page 561, So paragraph 32, page 561, it explains what the purposes of Article 21 and 22, which are now Articles 29 and 30, as between member states. And it explains that the reason why those were introduced is in the interest of the proper administration of justice within the community. And you'll see, and so in other words, within the community, where you have parallel proceedings that satisfy the triple identity test, that in and of itself gives rise to a mandatory stay because it's considered to be in the proper administration of justice. And just for your note, on the triple identity test, you'll see that set out at paragraphs 39 to 42. And in the Supreme Court in the Alexandros T, which is at volume 3, tab 22, page 587, paragraph 27, page 587. You'll see towards the bottom of that paragraph.
Sorry, paragraph.
Apologies, my lord. Paragraph 27, page 587.
Mm-hmm.
Just at the bottom, it just endorses that the Supreme Court endorses the TATRI in the context, again, Article intra-EU pending proceedings. The objective of Article 28 is to improve coordination of the exercise of judicial functions within the European Union and to avoid conflicting and contradictory decisions, thus facilitating the proper administration of justice. So, and this, of course, is also recorded in Recital 21 now of the regulation, which wasn't there previously. My point, for present purposes, that when you have satisfied 33.1, and this is important to then interpreting 33.1b in my submission, you have created a case, I'm not saying an absolute case, at least a prima facie case, that the nature of the risk of conflicting judgments warrants a stay because it's contrary to the proper administration of justice. And I rely on the fact that 33.1 is derived from Article 29. Now, Article 33.1b introduces what I describe as a lens broadening exercise. It talks about the court of the member state being satisfied that a stay is necessary for the proper administration of justice. Now, it uses, in my submission, the language of satisfaction and necessary rather than simply being in the administration of justice, because having passed through Article 33.1, you've already got at least a case that a stay is in the interest of the administration of justice, and now you have to be satisfied by reference to the lens broadening exercise of 33.1b. Now, the lens broadening exercise of 33.1b is the factors contained in Recital 24. And the question of what does all the circumstance of the case mean? The reason why this is important in my submission is, if you started from the proposition that there is a case in the proper administration of justice to avoid conflicting judgments, if the factors in Recital 24 don't take you any further one way or the other, a court, in other words, they're neutral, for example, a court may be satisfied that it is necessary for the proper administration of justice just on the basis of the risk of conflicting judgments that have satisfied the triple identity test. So I don't accept, and I'll explain. So in other words, the lens broadening exercise can take you higher up the scale, it can take you lower down the scale, or it can stay effectively neutral. I don't accept that the risk of conflicting judgments is simply a melting pot factor in Recital 24, as opposed to something that exists already as being in the administration of justice, and then one applies a lens broadening exercise under Recital 24. We therefore now need to consider Recital 24. Now, your Lordship has already put to me, well, you're allowed to take all the circumstances of the case. So you can take account of a non-exclusive jurisdiction clause. What I submit is that what Recital 24 is actually concerned with is not a comparative analysis as between the third state and the member state, which would be the type of approach one would apply in the context of forum non-conveniens in this jurisdiction, but it is only concerned with facts and circumstances relating to the third state and whether that affects the proper administration of justice. Now, before focusing on the language of Recital 24 and the examples it posits, all of which are concerned with the third state, not any comparative analysis, not any comparative considerations as to appropriate forum and so forth. What is important by way of background is Owusu and Jackson.
It's inevitably going to be a comparative exercise, isn't it? I mean, not looking at those factors in a vacuum. Obviously, if you're looking at, for example, at what stage has the proceedings reached in the third state, you're comparing them with the stage that the proceedings reached in England. If you're looking at whether the court in the third state can be expected to give a judgment within a reasonable time, inevitably, part of that assessment will be, well, how long would it be before you get a judgment in England?
Well, I don't quite accept that, my lord, and it's for this reason. The question is whether having entered through...
Let's say, for the sake of argument, you can get a judgment in the United States of America in 2 years.
Yes, my lord.
But in fact, for sort of fast-track reasons, you get a judgment out of the English court in 6 months. Are you seriously saying it's not possible to say, in that example, well, actually, given that you can get it in England in 6 months, 2 years is not a reasonable time, it's too long?
I am saying that, my lord. And the reason I'm saying it is that the administration of justice test is not comparing, it's not asking you to compare that jurisdiction with this jurisdiction. It's asking, well, is 2 years objectively too long? So if you were in a place where it's just going to take so long that you can't say that it's contrary to the administration of justice, then that would make a comparative assessment as between the third state and the member state for the purposes of then saying, well, this state does it quicker and therefore it's in the administration of justice to have it here. I don't accept that, and I'll take you to a little bit of material which in my submission supports that. But before we get into that, can I just remind the court of Owusu and Jackson, which is at bundle 2, tab 16. Now, as your the only relevant paragraph is 43 and page 438. As the court will recall, this is the case which remains good law under the regulation, that forum non-conveniens does not exist under the regulation. So in other words, you can't apply to stay proceedings where jurisdiction is domiciled here, where
But
there's
that's
no...
all to do with the position as between member states. It's got nothing to do with the position in relation to third states.
No, my Lord, Owusu and Jackson is concerned with third states.
Yeah, but what it says is, insofar as that doctrine is recognised only in a limited number of contracting states, whereas the objective of the Brussels Convention is precisely to lay down common rules as to the exclusion of derogating national rules.
My Lord,
Just looking at Article 29, for example.
My Lord, the point for present purposes is that when you consider a uniform interpretation to the administration of justice concept, and when you consider that forum non-convenience is not an approach understood by many member states, which is the point made here, when one looks at Recital 24, and you would have expected if in a lis pendens situation concerning a third state, if what was going to be done is a comparative exercise between a member state and a third state, there would have been very careful guidance.
It's dealing with a completely different issue. It's dealing with what's now Article 4.
Yes, my Lord.
And jurisdiction where the defendant is domiciled in a member state, and whether or not the doctrine of forum non-convenience has any application, and it was held that it didn't for fairly obvious reasons given the terms of the convention. But this is years and years before Articles 33 and 34 existed.
It was, my Lord, but it still remains good law in the context of Article 4. And the point I am making is that when you look at Recital 24, it doesn't ask all the specific examples that it gives. Your Lordship...
Article 33, I mean, forget, in a normal case,
yes.
Article 33 would apply to exclude Article 4, wouldn't it?
My Lord, my point is this. When you look at all the examples given in Recital 24, connections between the facts of the case and the parties and the third state concerned, the stage to which the proceedings in the third state have progressed by the time proceedings initiate in the court of the member state, and then also the existence of exclusive jurisdiction in the third state. It's concerned exclusively with examples by reference to the third state. It's not asking it's not engaging in a comparative exercise. The court is putting to me that because it says all the circumstances of the case, all should be read literally. I mean all the circumstances, including, for example, the existence of a non-exclusive jurisdiction clause, although all of the examples, in my submission quite tellingly, are all by reference to factors concerning the third state. And in my submission, that makes a difference. So the question is whether, and I'll take you a little bit of material which on all of this, but whether there is something about the proceedings in the third state, the connections and so forth, which means that it's not in the administration of justice. You can't be satisfied because, for example, the third state simply takes too long, not because it takes longer than here, but that it takes objectively too long, or because by reason of the connections of the parties and so on, you can't have a proper trial there and so forth. Now, if I may, my Lord, if we can go to David Joseph's book,
Yeah.
Volume 1, Tab 7, page 185. What he says there it's not so this is at 10.79 and the point he makes in the second line is the new provisions do not give a general discretion to stay proceedings on the grounds of forum non-convenience. The discretion which is introduced is targeted towards the proper administration of justice in the context of lis pendens in a third state. What I submit he is stating there is that one is concerned exclusively with focusing on the third state and whether you can be satisfied that the proceedings there can be conducted properly and adequately in the proper administration of justice, such that the risk of conflicting judgments means that you ought to stay, because the risk of conflicting judgments has already been established to exist, and then you're focusing on simply the third state, and that's why all the examples, so when it says all the circumstances of the case, in my submission it doesn't mean literally all, but only matters concerned with the third state. Now Briggs, tab 6, page 156.
Paragraph 1080 would suggest be against your case, wouldn't it? These provisions do not apply to jurisdiction asserted on the basis of an Article 25 jurisdiction agreement. He doesn't seek to draw a distinction there between exclusive and non-exclusive.
Well, but my lord, I've taken you to the passages, but my lord, but that doesn't address the question that we've been dealing with, my lord.
No, okay. Right, sorry, Briggs.
Briggs at page, my lord, tab 5, page 156.
Yeah. Right.
What he says at the top, it seems likely that a court may be permitted to make some sort of assessment whether the foreign court is one whose procedures seem likely to measure up to standards of procedural fairness and general suitability to serve as the substitute for an adjudication by the courts of a member state. No doubt there are sensitivities here, and a list of countries whose courts are not to be trusted will need to be found elsewhere. But in my submission, the real focus is on the suitability of the third state's court, and not, as I emphasize, a comparative exercise. Now, Dicey and Morris, which my learned friend relies upon, tab 8, page 203. Dicey and Morris takes, this is page 203 in the middle passage. This is the, I believe, the passage that's relied on by my learned friend. It takes a slightly different approach. It says, reading from the third line of the second paragraph, it's not dissimilar from that adopted in the common law. It is for the court of the member state to determine for itself whether a stay is necessary for the proper administration of justice. By the very fact that the court is invited to consider and assess proceedings in a non-member state means that the concept of proper administration of justice is not to be determined solely by reference to domestic considerations or to the operation of the European Union internal market in the proper allocation of jurisdiction. The concept of justice thus invokes a broad international concept underlying the general principles of independence. Now, I don't fully accept this approach. I don't fully understand what it means by an international concept. It's certainly emphasizing the fact that it's not a domestic concept and certainly not a domestic foreign non-convenience concept. But in my submission, when one has regard to the way 33 is set up and the entry into it being the risk of conflicting judgments, that makes a major difference. As your lordships and ladyship will be aware, in the context of normal domestic non-foreign convenience, lis pendens is simply a factor. It's not got any special weight. Although your Lordship may recall there was a time when it was thought to have special status. In my submission, in the context of the regulation, there is a difference. Now, my Lord, there are two other authorities which my learned friend relies upon. One is Volume 3, Tab 23, which is the Municipio case. This was a case where there were related Brazilian proceedings, and the question of whether or not there should be a stay under Article 34. And the passage which is relied upon is a paragraph 206, page 663. And what is said here is the decision in Owusu, to which I've already made reference in the context of the strikeout application, was directed at least in part against the risk that the application of the broad discretion afforded by the common law doctrine of forum non-convenience was liable to undermine the predictability of the rules imposed by the Brussels Convention and its successor. It follows that a defendant cannot circumvent the requirements of Article 34 simply by taking a forum non-convenience shortcut, however cunningly disguised. It does not mean, however, that provided the jurisdiction prerequisites have been satisfied, the court is required, when considering the proper administration of justice criterion, to jettison any consideration of factors thereunder, which might also be theoretically relevant to a forum non-convenience argument. So, such an approach would achieve the objective only of throwing the baby out with the bathwater. So, in that particular case, just for your note, at paragraph 226, the court concluded that the risk of irreconcilable judgments was the most important factor in the case. But my point for present purposes is that it is a different test to the non-forum convenience English law test. In my submission, it's focused on the third state and the question of whether you can be satisfied that a stay will be necessary for the proper administration of justice, i.e., are there factors relating to the third state and how, having regard to the connection of the parties and so on, that there will be a problem with the third state dealing with the matter. Now, the critical point, as your Lordship has already put to me, is the existence of the non-exclusive jurisdiction clause. That was said to be the most important factors, as the court will already be aware. Now, in my submission, that was wrong for a number of reasons. First, in my submission, the existence of a non-exclusive jurisdiction clause providing for non-exclusive English jurisdiction is not within Recital 24. In my submission, one is giving too much weight to the first sentence of Recital 24 and not enough to the illustrations given, which are all concerned with the third state. Secondly, and that distinguishes Article 33(1)(b) in my submission from domestic forum non-convenience, where the existence of a non-exclusive jurisdiction clause is considered to be a powerful factor. And an example of that is the UCP case in the alternative at paragraph 59, volume 2, tab 19, page 535. We don't need to look it up. The other difficulty in my submission with bringing in the non-exclusive jurisdiction clause at this stage is that it means that the scheme of the regulation on my case is turned on its head. On my case, non-exclusive jurisdiction is not engaged at the place of domicile and serves no function there, because its function is to as I've already said, is to find jurisdiction at a place which doesn't objectively exist. It would be a very odd result in my submission if one were to then, nevertheless, to bring it back in to the administration of justice factors in circumstances where one has already determined that jurisdiction is not based on non-exclusive jurisdiction. So in my submission, either non-exclusive jurisdiction wins at post 1 by ground 1, or if I'm right on ground 1, it should be irrelevant under ground 2.
Right. Now then, Mr. Dewan, it's gone 12:30. Have you agreed with Mr. Mott how time was to be divvied up?
We haven't, my lord. Of course, my learned friend must have a fair and equal amount of time. May I wrap up in the next 5 to 6 minutes?
Well, I think you better, really.
My lords, my lady, I'm grateful. So just to sum up, therefore, it was accepted by the judge that there was a risk of irreconcilable judgments. In other words, Article 33 was satisfied. In my submission, therefore, the first tier or first stage of the administration of justice test was satisfied, and one has to then see whether there's anything which detracts from that. That's the first point. The second point is a non-exclusive jurisdiction clause does not detract from it because it's not part of the Recital 24 analysis. The third point that I rely on is that once you take the non-exclusive jurisdiction clause out of the equation, the judge accepted that there were material connections between the parties and the third state. That's paragraph 109 of his judgment. In other words, there was nothing about the connections between the parties and the third state that detracted from it being appropriate in the administration of justice to stay the proceedings. And the only other factor, and what the learned judge did instead was to conduct a forum non-convenience exercise. That's at paragraph 109. What was said there was that this was neither a UK-centric nor US-centric dispute, but the centre of the gravity of the dispute was Slovakia, because that's where all the billing and was done. And in my submission, that sort of comparative analysis is completely outside of Article 33(1)(b. Because that didn't detract from the fact that there was nothing about the third state, the US proceedings in New Jersey, which prevented the proceedings in the proper administration of justice from continuing. And the final factor that the judge relied upon was the fact that English law governed. But in my submission, again, under Recital 24, and the fact that one is concerned with factors relating to the third state, this is not a material, and there was nothing which suggests, there was no evidence put forward that a US court would be ill-equipped to deal with issues of English law, which would go to the administration of justice. In those circumstances, in my submission, the judge approached the exercise of discretion from the wrong interpretive lens. If it pleases the court, those are my submissions.
Do you want anything? Nicola? Thank you very much, Mr. Yes, Mr.
My lord,
Our case is actually really quite simple, and that is that this court has jurisdiction under Article 25 because there is a jurisdiction clause in favour of this court which complies with the requirements of Article 25. And Article 33, on its express terms, is not engaged where the court has jurisdiction under Article 25. My learned friend's submissions focus on scheme of the regulation and gateways, but those submissions, in my respectful submission, are entirely artificial. None of this is found anywhere in the wording of the regulation, or indeed simply looking at its terms according to their purpose and in view of the interrelationship between the various terms of the regulation. Where jurisdiction is independently available to this court under Article 25, Article 25 simply doesn't engage Article 33, and that's really the end of it.
The fact that it's also available under Article 4 is neither here nor there.
It is also available under Article 4, and I don't dissent from that. There is concurrent jurisdiction, but there is nothing in the wording in my submission of the regulation which prevents the accumulation of grounds of jurisdiction. Still less is that the case where, if you like, the contractual selection reinforces the fundamental rule of domicile. So in fact, all roads point to a particular jurisdiction. And that's of some significance, because this is a case where the party's contractual selection, so the voluntary selection of the English court, coincides and reinforces domicile, and vice versa. So all roads, in fact, lead to this court. Now, Article 33, when we'll go through it, tends to be engaged where the jurisdictional link is at its weakest. So one only has...
Sorry, the jurisdiction?
Jurisdictional link with the member state court is at its weakest. So you've got the default rule, and then one has the elective special jurisdiction under Articles 7 to 9. And I'll be saying that, you know, where the contractual jurisdiction reinforces domicile rather than pointing away to another jurisdiction, there's even less reason to invoke Article 33 than there would be where jurisdiction exists only by reason of the non-exclusive jurisdiction clause, and there is no domicile, which was, of course, the case in UCP and Nectris. So what I was going to do in terms of the order I was going to take things subject to look at the first ground of appeal, just identify the purposes which are engaged when interpreting the regulation, or interpreting Articles 25 and 33 in particular, and also Article 4, and then just look at various scenarios to sort of test the proposition which my learned friend is putting, to see if this can conceivably be right under the structure and the wording of the regulation. Then also looking at just a couple examples of the actual wording of the regulation to see if that casts light on the interrelationship between Article 25 and Article 33.
Well, this regulation, like its predecessors, it sometimes gives rise to counterintuitive reactions, but I mean, there is something extremely odd about the idea that this non-exclusive jurisdiction clause would exclude Article 33 if the parties were domiciled in France, but it doesn't exclude them, even though they have to be domiciled in the same country as is given jurisdiction by the provision.
I mean, that was one of the points I was going to raise. I mean, that just cannot be the result, where you've got two parties domiciled elsewhere, and the only link with England is a non-exclusive jurisdiction clause. There's no argument, and there's no argument from Perform, that in that situation, Article 33 isn't engaged, because there's simply no one can argue that there is jurisdiction based on Article 4 or 7 to 9. One only has an Article 25 jurisdiction agreement as the relevant link. So if that's the case, where you've got parties domiciled somewhere else, could be in the EU, could be in a third state, and Article 33 isn't engaged, why on earth would it be engaged when you've got a jurisdiction clause in favour of the English court, and the English court also coincides with the defendant's domicile? It makes absolutely no sense and goes against the fundamental purposes of the regulation, by which I mean suing at the place of domicile, autonomy of the parties, predictability, and then irreconcilable judgments. And if I could just deal with those briefly, and then perhaps if I just go through the various purposes to have in mind when interpreting the regulation, that will take us to the short adjournment.
Yep.
Convenience. So in relation to those sort of four purposes which I will be saying are engaged, the first is domicile. And it's said that the domicile of a defendant is the basic rule of allocation of jurisdiction. And of course it is. It's the fundamental rule, it's the default rule. Nobody dissents from that. But one then has to ask, what is the purpose of that rule? And the answer, and this is supplied by Professor Briggs, it's paragraph 2.06 of his 6th edition, is that it is to prevent a defendant being sued against his or her will in a member state other than that of his domicile. And exceptions to that rule will obviously be construed narrowly. So a defendant can expect to defend him or herself at their home court. But of course that is precisely what is happening here. And where one has a jurisdiction clause which evidences that the parties consent to be sued in England, then there can be no question of the defendant being sued against their will. And this is really sort of quite a tension in Perform's case, because Perform says, well, domicile is the fundamental rule of jurisdiction, and one goes no further than that. But what, of course, Perform is trying to do is to stay the proceedings before the court of domicile in favour of the court of a third state. So what Perform is seeking to do is to go against the basic rule of domicile, not to reinforce it, as we are doing.
In fact, in a way, it's seeking to have it both ways, isn't it? I mean, it's relying on its freedom to start proceedings in the United States, despite your client's domicile here. And it's then relying on the domicile provisions in the convention in order to show how it's entitled to do that.
Absolutely.
Relying on the fact that it's an English domiciled company to deny the jurisdiction to the one court which it's agreed would have jurisdiction, albeit non-exclusive.
Indeed, my lord.
I mean, he may be right, but it's a frightfully unattractive position to adopt, isn't it?
Well, it's not right. But and the reason your lordship is just identified as one of the reasons why it's not right. It just simply cannot be the case. And as the court has also noted, one of the other main purposes of the regulation is to respect party autonomy. I mean, that's been the way right through the European jurisdictional regime. However, one of the innovations of the recast regulation was to lay greater emphasis on party autonomy, so that the autonomy of the parties to a contract should be respected, as long as that doesn't infringe on the exclusive or privileged grounds of jurisdiction, such as Article 24 or the insurance and consumer provisions. And one of the ways that there was greater emphasis laid was to recognise expressly for the first time non-jurisdiction agreements.
Non-exclusive.
Yes. I think Article 25, this time was the first time they had been expressly recognised, and that followed from the Pocar report. English authorities before this, there was a judgment of Lord Hoffman, said that the predecessor to Article 25, so Article 23 and I think Article 17, did in fact recognise them, but that wasn't apparent from a sort of literal reading, if you like. But what the recast regulation also did was to, for the first time, allocate jurisdiction to the contractually designated court where it has exclusive jurisdiction, even when it's second seized. So the first seized court has to stay in favour of the second seized court if the second seized court has exclusive jurisdiction. And that was a change in the recast regulation, given over its predecessor.
That's what's 31.2.
That's what's 31.2. So that's the new provision, which didn't exist before, which is why there were the difficulties before, where with parties rushing off to a different court, not the contractually selected court, first in breach of if you like, an exclusive jurisdiction clause. And this is supposed to stop that gamesmanship, if you like. There's, of course, the purpose of predictability, which doesn't need a great deal of elaboration, but basically parties should know where they're going to be sued, and the rules of allocation of jurisdiction should be predictable. But of course, in my submission, where you have a jurisdiction clause in favour of England and both parties are domiciled in England, the parties can expect it to be sued in England, and so no one should be surprised that this has happened. One then comes on to the final purpose, which I say is relevant, which is the avoidance of irreconcilable judgments. And the recast regulation deals with this in two different ways. There is, of course, the lis pendens proceedings provisions relating to intra-EU lis pendens, and then there's the provisions Article 33 and 34 applying to the third state. In relation to the intra-EU position, A stay is mandatory when one comes within Article 29, which is the equivalent of Article 33. That is in contrast to the position under Article 33, where a stay is only discretionary. And that is because of the sort of system of mutual recognition and enforcement of judgments, which applies in the recast regulation to judgments from courts of EU member states. And one of the grounds for not recognising another judgment from a judgment from another EU member state is if it's irreconcilable with a previous judgment from another EU member state. So the recast regulation and indeed its predecessors go to some lengths to avoid concurrent parallel proceedings and to avoid intra-EU irreconcilability, because that would undermine the purposes of judgments being easily exportable and enforceable. But of course, where proceedings are pending before a third state, and this is the first time any regulation within the EU jurisdictional regime has recognised pending proceedings in a third state. So even in cases of potential direct irreconcilability under Article 33, it's just a discretionary stay. It's not mandatory, and that's also the case even where there's an exclusive jurisdiction clause in favour of a third state. So even if you had an exclusive jurisdiction clause in favour of, say, New Jersey, there's not a mandatory stay on a third state lis pendens basis. So in my submission, where there are pending proceedings in a third state, the recast regulation tolerates the risk of irreconcilable judgments. And it tolerates that risk where the jurisdictional link with the member state court is at its weakest. And that, I say, is Articles 4 and Articles 7 to 9. And so we would ask the court to bear those purposes in mind when construing the regulation. And we say that where that leads is to a conclusion that where there is a jurisdiction agreement falling within Article 25, whether it's exclusive or not, Article 33 is of no application. And that has to be the case where the defendant is domiciled in the member state court, as well as where it's not domiciled in the member state court, which was the factual situation which was before the court in UCP. I mean, we say basically the position is a fortiori in a case such as this, where jurisdiction coincides with domicile. So in that situation, you had the additional element of the parties having voluntarily selected the English court, so that contract reinforces domicile. And so if this court were to retain jurisdiction, this court respects party autonomy, it respects the right of the defendant to be sued in their home court. It's also consistent, entirely consistent in my submission, with the aim of predictability. So that's where I think I would end with the court's permission in terms of the relevant purposes, and I was then going to go on to look at various jurisdictional scenarios.
Sorry, do you want to?
Oh, sorry, I said that was the end of the section on the relevant purposes.
Well, do you want to go on? Because
I can go on. Yes, I thought that might be convenient, but obviously
no, it's only 10 to 1.
Rechecked.
Only 10 to 1.
Which it was not.
So I thought you might have finished.
You never know you're not. A very convenient outcome for everybody. I mean, my first point was really going to be to look at the position by reference to where Article 33 is not engaged, and the court is already alive, I think, to the main points. And it's a point that the judge was alive to also, that there's certain common ground, I think, between us, and the confluence of that common ground has certain implications for when Article 33 is not engaged. It's common ground, I think, that, well, it's a tenet of my learned friend's case, that where there's an exclusive jurisdiction clause within Article 25, Article 33 is not engaged. There's no argument that jurisdiction is based on Article 4 in those circumstances.
But it's difficult to see how that argument runs as a matter of construction of the regulation.
Well, given
that the Article 25 doesn't draw a distinction between exclusive and non-exclusive.
No, it doesn't, my lord.
Except
what it says is a presumption that a clause.
Presumption of exclusive, but it's recognising that if it's a non-exclusive jurisdiction clause, then the the chosen court shall have jurisdiction
Unless it's invalid.
unless it's invalid.
Indeed, my lord.
And so, speaking for myself, I don't see where you get to this idea that somehow if it's exclusive, it ousts Article 4, and if it isn't, it doesn't. Just
No, my lord, nor do I. I don't think you need to get into questions of ouster. One certainly has to understand the interrelationship between the various rules to see whether, for example, so one has to understand, if one has an exclusive jurisdiction clause under Article 25, that may have to give way if you're before the courts of that would have jurisdiction under Article 24. So
I suppose you would say, giving Article 33(1) a purposive construction, what it's really saying is where jurisdiction is either only based on Article 4 or Articles 7, 8 or 9, or based on Article 4 or on Articles 7, 8 or 9, and not any other provision of this regulation, something like that.
That could be the argument. I mean, that isn't the argument that's put on, but it's also, in my submission, I just don't think it's...
Well, you can look at it in a number of ways. What you essentially say is, well, where there's parallel jurisdiction,
Yeah.
then you're entitled to say, well, in this case, jurisdiction is based on Article 25. But another way of looking at the same point would be to say that this provision is dealing with situations where the foundation of the jurisdiction is only one or the other and not something else, such as 24 or 25.
My lord, yes. I mean, it doesn't use the word only, obviously. I mean,
No.
Because one doesn't tend to find things phrased that way in the regulation. From our perspective, it might have been helpful if they'd said it's only this or only this, and for the rest of the time, Article 33 doesn't apply. That might have been clearer. But,
Yeah.
but that's obviously not what's happened. So one has to look at it sort of iteratively in terms of what they must have meant, what the drafters of the regulation must have meant. But I mean, I have to say, when I read it for the first time, I just thought, okay, well, that's fine. We're within Article 25. We have a jurisdiction clause. That recognises both parties' voluntary choice. Okay, both parties are domiciled here. Jurisdiction's based on Article 25. All right, it might also be based on Article 4. There's no problem with accumulating jurisdictions. When they reinforce the jurisdiction of domicile, there's more a problem for accumulating jurisdictions where you want to go somewhere else, because then you have to justify it. Here we've got enhanced justification, if you like, because you've got the contractual selection.
Yeah.
And really then, the second point on this is simply that there's a UCP point, that if the court had jurisdiction in UCP and Article 33 wasn't engaged, because you've got two parties which aren't domiciled here and there's only a non-exclusive jurisdiction clause. If that's the case and Article 33 doesn't apply there, there's no logical reason you could say why it should apply where you've got an additional link to the jurisdiction, which is domicile. But of course, on Perform's case, the position is transformed by the coincidence of domicile and the non-exclusive jurisdiction clause. And so really on Perform's case, whether or not Article 33 is engaged or not in a jurisdiction clause case depends entirely on where the defendant is domiciled, and more particularly whether they're domiciled here or not. And that, we would say, would be entirely arbitrary. One would never be able to guess that result from reading the regulation. And moreover, there's absolutely no purpose underlying the regulation which would require one to interpret it in that way. I mean, and looking at the purpose of Article 33, so the intent to avoid the risk of irreconcilable judgments, it's simply illogical to say that the recast regulation accepts that risk of irreconcilability where there's a non-exclusive jurisdiction clause and no other jurisdictional link, but is prepared to tolerate that, or not prepared to tolerate the risk, because that Article 33 would apply, where there's domicile and a non-exclusive jurisdiction clause. There's nothing in the purpose of the article that says, right, we're not going to worry about risk of irreconcilability over here, where there's only a jurisdiction clause, but we are going to worry about it where there's a jurisdiction clause and the defendant is domicile. And in one, Article 33 is engaged, and in one situation, it's not. And that being the case, in my submission, I mean, my learned friend's case or the interpretation of the regulations certainly just can't stand up. And then my next topic was going to be, although it's linked, is the reinforcement of domicile point, because the purpose of the domiciliary rule is to prevent the defendant being sued against their will. The fact that the jurisdiction agreement reinforces the domiciliary rule has some considerable significance when considering how to interpret Article 33 and deciding whether it should apply so as to allow a stay of proceedings before the court of domicile. Because Article 33 is looking to the circumstances where it might be appropriate to cede priority to a third state court, and where there's a jurisdiction clause and where domicile coincide, there's simply less reason to cede priority to a third state court. Now, it may sound obvious, but there is a little bit of authority on this in the Etihad case, where the court went back to one of the earlier CJEU decisions of Meath and Recital. But it may be this time it may be a convenient moment.
I was about to say, I
adjourn
think
before I go to Meath.
I think we'll turn to Etihad at 2 o'clock.
Great.
Thank you.
Goodbye.